Okay. Good afternoon, distinguished panelists and distinguished delegates. My name is Tobenna Erojikwe, and I am the chairman of the board of the Institute of Continuing Legal Education. Today is day 2 of the second edition of Intellectual Property Law Training for Lawyers. And our speaker for today is Mr. Obafemi Agaba. I welcome you all to today's session, and I'm quite encouraged with the participation that we saw yesterday, and we hope that many more people will participate today. Please, if you have friends that are experiencing difficulties with connecting, they can also join us through YouTube on our YouTube channel. So now to introduce Mr. Femi Agaba, who will be speaking on intellectual property due diligence. Obafemi Agaba is the head of the Litigation and Dispute Resolution Department of the full service commercial law firm of Jackson, Eti and Edu. He is a consummate commercial lawyer who started off in general commercial litigation and very quickly became renowned for his mastery of the specialist area of brand protection, encompassing intellectual property rights, litigation, anti-counterfeiting, commercial IP transactions, IP policy, amongst others. Related to this expertise is his growing reputation in the field of technology litigation, TechLit, where he has, in the last 4 years, been representing some global leading entities in the new social media space, as well as the fintech sector. In litigation, advisory, regulatory, and policy, he's included on the panel of neutrals of the World Intellectual Property Organization, WIPO, where he has been appointed as mediator in copyright software technology mediation, amongst others. As a proficient commercial dispute resolution practitioner, Obafemi represents many local, international, and multinational clients in diverse areas such as oil and gas, labor and employment disputes, construction, torts, boardroom and corporate restructure litigation, regulatory compliance, crisis management, litigation portfolio management. His litigation portfolio management is one special skill set he has and has mastered the management of several court cases across different parts of Nigeria, cutting across a variety of subject matters for several clients. The clients benefit from economies of scale, institutional knowledge of their businesses and related disputes, multi-city locations, and local knowledge of various court nuances, as well as the project management skills he brings to bear in such portfolios. In addition to being head of litigation and dispute resolution practice, he's presently the chairperson of the executive committee of the firm and co-head fast-moving consumer goods sector, where he employs his significant industry experience in designing tailor-made technical and business solutions which speak directly to the unique challenges faced by clients in the sector. As a champion for everything IP, Obafemi is currently the president of Intellectual Property Law Association of Nigeria, IPLAN. He is also the subcommittee chair 2023/2022 Legislation and Regulation Subcommittee for Middle East Africa, South Asia, MESA of the International Trademarks Association, INTA. Distinguished colleagues, it is my pleasure this morning to introduce to you Mr. Obafemi Agaba, who will be taking us on today's lecture. Mr. Agaba, you're welcome. I yield the floor to you now.
Thank you very much. Thank you very much. Good afternoon, ladies and gentlemen, dear colleagues. It is my pleasure to be here today, and I consider it a great privilege to be given the floor to share experiences, to share knowledge with highly cerebral Nigerian lawyers. So I do not take this for granted. A big thank you to the organizers as well for the brilliant job they've been doing over the years, and to Professor Bankole Sodipo, who opened the floor yesterday, and just trying to see how much I can fit into the shoes of the renowned professor of IP and senior advocate of Nigeria. So you will take me as I am, but we'll try and do it justice. To the topic of the day, intellectual property due diligence. Intellectual property due diligence. And I want to say that perhaps the term due diligence is probably more in the terrain of our colleagues that do commercial transactions. I'm trying to change my slides. Okay, good. So, taking it, the topic of the day is intellectual property due diligence. And I think it's important for us to put things in context, to situate things properly so that we can understand where we're coming from and understand the core issues we're about to discuss. Intellectual property. What is intellectual property right? I know Prof did a lot of definitions, a lot of introductions to the basic concepts and to the different types of IP rights yesterday. So I'm not going to go so much into that, but I think that the background that I want to lay is very fundamental to us understanding the peculiar concept of due diligence in IP transactions. So what is intellectual property right? It is the legal recognition of the right of an individual or a company to claim ownership and exclusively exploit the produce of their intellectual or mental exertion. So the starting point is that intellectual property is the produce of the mind, is a product of our intellectual exertion. And we're saying that it becomes a right because the law, the national law, or even international law, as the case may be, has conferred some right on the creators of this work, on the man who has exacted his intellectual prowess in coming up with the work. The law has granted him some right of ownership. And coming with the right of ownership is the exclusive right to exploit the produce of his mind, whether such produce of his mind is manifested as an invented product or process, or creative works of knowledge or entertainment, aesthetics appeal of a product, or trade insignias of product or services. So if you look at the definition which we have just given of intellectual property rights, we are simply saying that it's got to do with the right that has been given to a person or a company over the products of its intellectual exertion, which may be manifested in different ways, such as an invented product or process, which will bring to mind patent, creative works of knowledge or entertainment, which will bring to mind copyright, or aesthetics appeal of products, which brings to mind industrial designs, or indeed trade insignias of products or services, which calls to question trademarks. And we've said that the laws of many nations, including our dear Nigeria, recognizes the need to protect intellectual property rights. Having said that, the next question we want to determine in order to properly situate the discussion of today is, what is the nature of intellectual property rights? We have the definition, but what is the nature of this right? Does this right have a peculiar nature which we need to put into consideration when we are dealing with it? And we there say that intellectual property right relates to pieces of information which can be incorporated in tangible objects at the same time and in an unlimited number of copies. Now, so let's look at that again. It relates to the pieces of information which can be incorporated in intangible objects at the same time and in an unlimited number of copies. What this tells us is that when you're dealing with intellectual property rights, it would seem to be in an intangible form in itself, however, represented in a tangible form. So the IP right in itself is intangible, it's incorporeal, it's abstract in nature. However, you may be able to represent it in a tangible form, in multiple copies of such tangible form. The real thing to note there is that the property is the information in itself and not the physical copies of whatever it may be. For instance, Eze Goes to School is a popular book some of us read in the days before the Android. And you find that the intellectual property we're referring to there is the literary work which the author of that book has put together, not the physical book in itself. So it tells us the nature of IP rights immediately. It focuses on the rights which are enjoyed in the produce of the mind rather than the produce itself. Okay, so the nature of intellectual property right is not in concrete form, it is abstract. So I think we get that point. And so that takes us back that in real terms, therefore, intellectual property is the body of legal rights which may be asserted in respect of the product of the human intellect. So what is intellectual property legal right? It says that it is the body of legal rights which may be asserted in respect of the product of the human intellect. So that's the nature of intellectual property right. And very quickly, we just ask ourselves these very simple questions. What are the various types of intellectual property? And we just quickly say that intellectual property bifurcates into two majorly, and those will be industrial property and copyright. And when we say industrial property, we are referring to three types of intellectual property rights, and these are patents, which largely deals with inventions. I think Prof did a bit of more, extensive discussions on that, so I won't go into the details of that. But industrial property would include patents for inventions, trademarks, and industrial designs. If you look at these three types of IP, you'll understand why they are referred to as industrial property. Patents, trademarks, industrial designs are things that are involved in the process of manufacture, in the process of production, industrial, they are subjected to industrial use. On the fourth type of IP is copyright. And copyright will deal with things like literary works, musical works, artistic work, and we now have to start using the term audiovisual work, which is the new term that has been introduced in the Copyright Act 2022. I think Prof said, should we say 2022 or 2023? But I think the Gazette says Copyright Act 2022. Before now, this would be cinematography, but the new term is audiovisual works. And the other types of copyright would be sound recordings and broadcast. So these are the various types of intellectual property rights. But I dare say that these are the fundamental types of intellectual property rights, but there are some other related rights that have some semblance of IP rights, and that would take us to things like confidential information and what have you, trade secrets and things like that. I think it's something we may touch on later on. So we've tried to understand, it's a step-by-step, what is IP right? We've looked at it. We've looked at the nature of IP right. We've then said that, therefore, this is what legal right in terms of IP means. So what is IP law? What is IP law all about? And we're saying that IP law regulates the creation, the ownership, the use and exploitation of the abstract rights derived from creative products. That is what IP law is all about. It's all about the regulation of the exploitation of those abstract rights that are embedded in the creative products. Okay? So it is a mechanism by which the society protects the interest of creators by granting them some form of property rights, some form of monopoly, limited monopoly over the creations and inventions emanating from the power of their brains to reason. And we've seen the different types of this. So that's what IP law regulates. And quickly, if you're thinking about why should the law protect IP, the simple rationale for the protection of IP is that if you protect IP, it means that the person who has created the IP is able to exploit it commercially, makes a living from it, from which it can buy his food, drink water, pay school fees, have a shelter, and have a little to go to Mauritius on holidays with himself and his family. And if he's able to meet all his basic needs and afford some luxuries by virtue of the power of his mind to reason, it means the man would be encouraged to further produce this kind of works. And the point we're making is that these works are of value to the society at large, whether in form of entertainment that it affords to us, or in terms of education, which it brings to enlighten our minds, or indeed in terms of technological breakthroughs and advancements, which it brings to the society, or the cultural heritage and representation with which it projects us as a people. All of these, at the end of the day, have an impact on the national interest, whether in terms of the advancement of commerce and economy and the tax that will come back to the government from it, or the international reputation that we get from it. No matter what they say about Nigeria today, at least people in our entertainment sector are beginning to give us some semblance of good reputation as Nigerians. And you find that there are even other Nigerians in the legal sector, in the financial sector, in the medical sector abroad that are doing a lot of intellectual exploits that are of good to Nigeria. So the point is that there is a need to protect intellectual property in order to stimulate development, in order to stimulate commerce, and from which the nation will gain, and also the individuals who are the creators would also be able to sustain themselves. Now, the next thing we're looking at is the metamorphosis of intellectual property. The metamorphosis of intellectual property. A lot of people, sometimes when I say I do IP law, they ask me the question, is that of relevance in Nigeria? What is intellectual property all about? Why are you talking about this in Nigeria? Is it just an academic exercise? We dare say no, and the answer has always been no, and I think the no is more than ever before a no, because of what we have termed as the metamorphosis of IP. Now, if you look at it historically, you will find that for every organization, or for most organizations in the past, all they were more concerned about were the physical assets which the company had, in terms of the goods they had, in terms of real properties they had, in terms of machineries they had. All these were the elements by which most companies would evaluate and assess the wealth which they think they have, their value, were assessed on the basis of their physical assets. And even when they feel that they have some form of intellectual property, their intellectual property was seen more or less as a sword or a shield rather than any other thing. And in other words, it was seen as a sword to attack anybody who they feel wants to infringe their intellectual property rights, or they use it as a sword to defend themselves when anybody wants to attack them in respect of their intellectual property rights. So they do not see, or they didn't see it beyond just being a sword and a shield. And they just felt that, look, it's my right. This intellectual property right belongs to me, and therefore I alone should be able to exploit it and derive any pleasure therefrom. Okay, so when companies are talking about what their competitive advantage is, all they think about are those, physical, their tangible assets, and IP was not seen for the real value which it carries. Okay, so, and that's why you find that most commercial transactions, even securitization transactions, would always be around tangible assets. And very annoyingly, a lot of companies saw IP more as a cost center, as just something for which the company spends money and the company derives no real direct benefits from. We dare say that this has become a myth, and this has become something of the past because of the metamorphosis of intellectual property. The emergence of the knowledge-based economy, sorry, I need to change the slides. So the emergence of the knowledge-based economy and the mutation of IP, okay? So what we are saying is that, look, when we take a look at the global trend, the world economy itself is moving, or has moved, from all the traditional, basis of commerce to a knowledge-based economy. We are all talking about innovations. We are all talking about inventions. We're talking about innovations, chat, GPT, all those things changing the face of the world, the face of the commerce. And what this has brought about is a complete mutation of intellectual property. What we are seeing today is that the emergence of the information technology world and the knowledge-based economy have put intangible assets at the forefront of commerce. They are at the forefront of commerce, and they're now the Cinderella of the law and the doyen of the assets of a company. Now, the point we're making, if today, honestly, if today, somebody comes to me and says that, Obafemi, would you accept from me, let me see, would you accept from me a co-hotel, or would you take from me the exclusive ownership of the Coca-Cola trademark? Today, I will gladly take the Coca-Cola trademark because I know the worth of that trademark as an intellectual property asset. Many years ago, I'm talking about 5 years ago or more, I think it was assessed to be worth about $67 billion. I'm not sure what it is today. And it can only continue to grow with the goodwill surrounding that trademark. So the point we are making is that today you find that the intellectual property assets have become the doyen of the assets that any company may possess over the physical assets they may have, whether in terms of real property or even machineries and what have you. So it has become very key to maintaining competitive advantage, has become the differentials for any company. You'll find out that the intellectual property assets of a company, anything that happens to it may very well destroy that company to the very last. I've had clients that their IP rights were compromised, even in terms of as being simple as their domain name. And when they didn't have any assets to operate their domain, it became a problem for the whole company. The whole company could not function. That underscores the importance of intellectual property assets today. And some of us are very happy to note that intellectual property rights have moved from being a cost center to becoming a revenue stream for the company. It is no longer the case that all you see about intellectual property is that it takes away money from the purse of the organization. Rather, it adds money to the purse of the organization. Ladies and gentlemen, where are we today? The mutation of intellectual property has led us to what today is now a different field in the practice of intellectual property. And that is what is called commercial IP commercialization. So even for those of us who are IP practitioners, our work as IP lawyers has evolved over the years. It has evolved beyond portfolio management. It has evolved beyond prosecution of IP rights. It has evolved beyond the protection of intellectual property rights. It has evolved beyond the enforcement of intellectual property rights to what today is regarded as commercial IP. And so what is commercialization of IP? It is the process of bringing IP to the market in order for it to be exploited in return for business profits and or growth. Let's take a pause on that. So commercialization of IP is the process of bringing IP to the market in order for it to be exploited in return for business profits and or growth. It creates new streams of income for the organization, whether on your own or through partnership or via combination of the two. So let's look at the progression. We're saying that commercialization is the process of you bringing your IP to the market, to exploit it in the market, to commercially exploit it and make money from it. And we're saying that in even taking this step, it could be you directly exploiting your IP rights and making direct revenue from it, or it could be through a partnership or combination of the two. So at the end of the day, it is important when we want to commercialize your IP, it is important that you first of all identify what are my IP assets that I may be capable of monetizing. So what we are saying is that IP has moved to the point of commercialization. You find that what you have today is not just a sword or a shield anymore, but that what you have is capable of being converted into money, into cash. So how do you know what you have today and the capacity of it to be converted to raw cash for the organization? That is why we always recommend that every organization needs to embark on an IP audit to determine what you have as intellectual property assets and the strengths and value of what you have as intellectual property assets. So it's important for you to do an IP assets. And we've said that you need to be able to exploit your IP. And as I've mentioned, what are the different ways by which you can commercialize your IP? We said there can be self-exploitation, where you're selling things that carry your IP yourself. So Coca-Cola, for instance, is the owner of Coca-Cola and directly manufactures Coca-Cola beverage. Okay, so that is self-exploitation. Exploitation. Debt financing is also one. If you want to take a mortgage or you want to go into any form of debt arrangement, even with the banks today, you want to obtain some facility for the bank for projects, we're saying that today your IP asset is something that can be used for securitization. Again, another way by which you can exploit is assignment or licensing. You can actually assign in its entirety your IP rights, or you grant some form of licenses, whether exclusively so or non-exclusive licenses to those you may want to. So what we're looking at is commercialization of IP. So again, let's take a further look at IP contracts. Let's take a further look at manifestations of IP in contracts. When you look at the screen now, you find that I was saying that IP in contracts may broadly manifest in two ways. You have IP in commercial transactions, and you have core IP contracts. When you look at IP in commercial transactions, we are talking about transactions that are not necessarily about intellectual property, but there are other commercial arrangements, but has IP content. Or sometimes we don't even avert our mind to the IP content of such transactions, but the reality today is that the IP content may, at the end of the day, be the deciding factor of the success or otherwise of such transactions, or might be a reason for people to bite their fingers at the end of such transactions. What are these types of transactions that we believe and urge people to avert their minds to the IP elements when they are going into them? Mergers and acquisitions, private equity related transactions, debt financing, securitization, joint venture, all of these things would always have IP content in them. And it is not the way they taught us in law school, where IP was reserved for towards the end of our sojourn at the law school, and they probably talked about it for 5 minutes. I think is a fundamental error. It's an important part of the law that needs to be taught very well. So in your mergers and acquisition, we're saying that IP may very well destroy the whole essence of it. So apart from IP in commercial transactions, you also have core IP contracts. This would include things like technology licensing, software licensing, dealings in designs, trademark licensing, dealings in patents, collaborations. You find that a lot with universities. And when you are looking at trademark licensing, it could also take different forms, such as merchandising, franchising, co-branding, brand extension, and what have you. Now, ladies and gentlemen, it is important to point this out in order to properly situate the core subject of our discourse this afternoon, which is IP due diligence. The essence of IP due diligence is to be able to get all these form of transactions right. And that is why we thought it important to avert our mind to the different kind of transactions that may require IP due diligence. So we're narrowing down more. So what we're dealing with now is what? Circumventing the pitfalls in IP contract. Really, at the end of the day, that is what IP due diligence is all about, is a tool towards circumventing pitfalls in IP contracts or commercial transactions with IP elements. In point of fact, I would dare say that any contract you are going into, please open up your mind to the possibility of IP elements that may be contained therein. So what is IP due diligence? It is a comprehensive evaluation carried out by a prospective buyer or licensee towards assessing the financial, commercial, legal benefits, and risk linked to a target company's IP portfolio before it is bought or invested in. So, ladies and gentlemen, you are in every transaction, the M&A transactions, the private equity transactions, you have the investor and you have the target company. In mergers and acquisition, you have the company that wants to buy out and you have the target company. And so the target company has its assets. And we're saying that the intellectual property assets of the company is what consideration. So due diligence is that comprehensive evaluation carried out by the prospective buyer or licensee towards assessing the financial worth, the commercial significance, the legal benefits, and the risks that are linked to a target company's intellectual property portfolio before you go wholeheartedly into such transactions. It's a legal exercise wherein skilled IP counsel defines, examines, and analyzes an IP portfolio of a target company, either offensively to purchase or in license, or defensively to sell. I would say that on this second one, that definition captures beyond the concept of intellectual property due diligence, but also captures the essence of IP audit. Because I would say that effectively, IP due diligence is more on the side of the one who wants to purchase, which is on the offensive, and the defensive would be on the side of the one who wants to sell, which, strictly speaking, will speak more to the IP audit. And therefore, it is important to draw the difference between IP due diligence and IP audit. So IP audit is conducted internally and at the request of the owner of the intellectual property. So if Microsoft wants to conduct IP audit, it's an internal process by the company to try to evaluate, identify what intellectual property rights do they have? What is the legal status of those rights? Are those rights still valid and subsisting? Do they still inhere in them, or they have been subject of third-party rights for one reason or the other? So that at the end of the day, they can know their worth from an IP perspective. It's an internal process that a company would conduct or engage consultants to do on their behalf. Whereas the IP due diligence is performed externally at the behest of a potential investor, purchaser, or business partner. So the point is that IP due diligence is usually conducted by the one who wants to buy a company or who wants to invest in a company and wants to understand the assets of the company beyond the physical or real assets to the intangible assets, which may be of great value or may be dangerous to the transactions. So it is an inquisitive mind of the buyer that goes into the company to look at all the things happening there and determine what intellectual property rights exist in the company and what is the strength and value of such IP rights. So at the end of the day, why is the need for IP due diligence? And we're just saying, part of this we've discussed, just to reiterate, to mitigate the risk of relying solely on the vendor's warranties and indemnities that may have been given to you. Yes, we go into transactions and there are warranties and indemnities, and we say, okay, we are placated, we can go into the transactions. But I think my people have the saying, things around Igboro or something like that. In other words, it is important for you to listen instead of you coming back after the deed is done. So it's better to avoid things. So rather than just rely on warranties and indemnities that may become empty, it might be more expedient to conduct an IP due diligence to know the real state of the rights which you want to go into. So to identify the real status of the assets and uncover any latent issues, to assess the critical success factors of the IP asset, including the strengths and weaknesses, to aid the investors' informed judgment in the course of the transactions. So these are, some of the reasons why we would go into IP due diligence. Now, we've talked about the need for IP due diligence, why it is important, why we need to do it to protect ourselves, to fortify ourselves against any eventual loss. What are the steps towards conducting an effective IP due diligence? What are the steps towards conducting an effective IP due diligence? I dare say that this may be summarized in 3. I call them the IDA of IP due diligence. And the first one is the need to identify the products and services of the target company and the various intellectual properties that are used in relation to such goods and services. So the first is identification of goods and services and the relevant IP rights attached to them. Secondly, is to determine whether the identified assets has protection under relevant legal regime, to determine whether those assets and their enabling intellectual property rights have due protection under the relevant legal regime. And finally, is to ascertain the vendor's ownership of those rights and the validity and subsistence of those rights. We can just take a look more at this. So the first one we mentioned is the need to identify. And this is largely fact-based. It's a question of facts. You are going there to try to identify what are the goods this company is involved in. What are the goods you manufacture? What are the goods you sell? What are the services you render? When you identify the various goods, as one conducting it, you want samples of these goods, from the sample of the actual good to the packaging and everything. And you want to then identify what are the associated intellectual property that are used in respect of these products or services. This could be trademarks. Trademark itself could be a word mark. It could be a logo. It could be a trade dress. And importantly, the trademark may be registered and it may not be registered. All of these you would need to identify. The fact that it is registered gives you some comfort. The fact that it is not registered does not necessarily demean the value of that trademark. All of these we need to put into consideration. Confidential information. Some things are not the traditional IP rights. They are not registered, but they are of serious value to the organization. So you will need to identify what confidential information, trade secrets, and know-how. How are they documented? How are they kept and safeguarded in the organization? And what value can you ascribe to them by virtue of the way they have been managed or they are being managed in the organization? Patents, industrial designs are things which you want to take note of. Copyright, customer lists, databases, slogans, brand hashtags, domain names are all the different things which you need to identify whether a particular organization has and how they use them. Moving away from identification, we go to determining whether the identified assets and the attendant intellectual property rights are protected. So the focus of the second phase of the process is to determine whether the identified assets enjoy protection under relevant legal regime. For instance, when you did your identification, you were able to identify a number of products and you saw a number of trademarks being used in respect of this product. The question that would agitate your mind is, these trademarks, do they enjoy protection under relevant laws. For instance, are they registered at the Nigerian Trademarks Registry? Have they been issued with trademark certificate, which will enable them be able to sue for trademark infringement or be able to defend themselves against any adverse trademark exploitation or even action. Even where the trademark is not registered, are you able to ascertain that the company has put that trademark to good use in relation to the product, in relation to their business, in a manner that may be said that they have acquired substantial goodwill in the business of manufacturing or marketing that product using that trademark? Because such acquisition of substantial goodwill in itself becomes a common law right that is capable of protection in its own right. These are the questions you want to ask yourself at this stage of the IP due diligence. And of course, it may involve you going to relevant registries to check the status of the registrations of such rights, especially patents, trademarks, industrial designs. Again, for copyright, which is not a registrable right, we know that the Nigerian Copyright Commission encourages the deposit of work called notification. Some of them, if you think they have notification, and notification may be of any value, of evidential value, even though it does not confer a legal right, but may have some evidential value. Have they taken such steps? Are some of the things you want to consider? Are there other ways they can protect and establish the ownership of the copyrights which the company has? Is some of the things you want to put in mind at this stage. And then ascertainment. Once you have done this, you want to ensure that the goods and services which you have seen and the various IP rights that are used in respect of them, you want to ensure that these rights are indeed owned by the company and not assumed. I have found situations where a company have been using rights and they just assume they are the owners, as they've never taken any steps to assert their ownership, whether in terms of registration of their company names, registration of their trademarks, or allowing other people to use it without them intervening, and they just assume they own it, when in point of fact, it turns out they didn't own anything. And in fact, where you own it, are you sure what you think you own remains valid and subsisting? All the trademarks which they have, which you are interested in, the company may have shifted the focus of their business, and as a result of that, may not have been renewing those particular trademarks. That particular trademark may be of relevance to you as an investor or as an acquirer. You want to make sure that such is renewed and becomes subsisting, in the books of the law. These are things which are important for us to put into consideration as the three-step of IP due diligence. What I have done in the number of the next succeeding slides is just to give us maybe a sneak peek into the IP due diligence questionnaire. When you're going into IP due diligence, you must have your questionnaire ready to be answered beyond what you might find on ground at the site. So on patents, some of the questions you might want to have on your questionnaire will be, have the list of all the inventions owned or used, whether or not they are patentable or not. You want to have the list of these, and the ones that have obtained a patent, you want to know. Obtain technical description of products and the manufacturing processes. Assess procedures to identify patentable inventions, because every company might be doing a lot of things, and sometimes they don't even know that they are creating IP in the process. So you must assess the procedures which they have to identify patentable inventions, and are these effective and are they being applied? Copies of all patents, including those which have expired. You must have all of these. Have copies of all licenses, assignments that have been executed in respect of such patents. These are just examples for trademark. Again, we've given examples of some of the things you want to have on your questionnaire. Industrial designs, we have put some things there. Copyright also has some checklist of things which you want to watch out for when you are conducting the IP due diligence. Also for trade secrets, all of these are things which you want to put into consideration. You also want to consider infringements. Are there infringements of third-party IP rights owned or used by the company? So are you using third-party, is the company using third-party rights which may erode the profits of the company in a case where damages are awarded by them and you find that you do not have anything in that company? Or are third parties using the IP rights of the company without them deriving any benefit from it? These are concerns which you want to avert your mind to. Okay, so these are some of the things we just thought we should give examples of, so you must have an IP questionnaire, IP due diligence questionnaire when you are embarking on such things. And some of the places where you look to when you are conducting IP due diligence, I mentioned some of them earlier. You have to look at the official records of the company itself. You have to look at the trademark registry. The CAC is another place where you need to look at the patent registry. All of these, you have to do your own review of the products, of the processes of the company. You have to do some online and internet searches. The trademark journals becomes very important as well. At the end of the exercise, you have to produce the IP due diligence report. The IP due diligence report is a concise but detailed summary and analysis of the findings made in the course of the investigations. After all, IP due diligence is all about investigations. And all of your findings at the end of the day would be the basis for your advice and recommendations to the investor. So it is important. A typical report should restate the client's instruction in order to determine the expected outcomes and exercise. And I always say that it's important to restate the client's instructions because it helps you to situate what you are doing and put it in context. So that when there are any controversies, you can easily reference the instructions from which you have proceeded. Okay. So your advice and recommendations must not be a product of your personal desire, but must be an objective product of your evaluation and the findings from your evaluation. So you cannot see something else and go and give another type of recommendations. Okay. Now, it is important that as you find information, especially some information that might be very crucial, it is important that as you find them, you should communicate them to the to your instructor even before the end of the exercise, because some things are so fundamental that you need not wait to the end of the exercise before you throw it. I think that's a good practice that is important to keep in mind. Now, we have seen that IP due diligence is a form of investigation that is conducted, and you're going to be looking at a lot of things to make your deductions, to make your recommendations. However, for so many reasons, apart from the fact that we are but human, it may be humanly impossible to guarantee the absolute accuracy of the data collected, as for instance, say that there is no prior art in relation to a patent under investigation. All that may be done in the circumstance is to diligently search and confirm what is known while leaving a margin of human error. So it is important to always have that statement of assumptions and that statement of human error just to cover our back is important. And a periodic post-acquisition due diligence exercise may also be explored for a strategic management of the IP assets of the investor. Ladies and gentlemen, all we have done this afternoon is to tell ourselves that in today's world, IP, intellectual property assets, have moved from being cost center to the organizations to becoming an income revenue stream. It has become so important, not just to IP transactions, but to other commercial transactions, such that the IP element of such transactions is capable of derailing the whole transaction or bringing about losses to the investors. To this extent, it is important to conduct intellectual property due diligence whenever we're going into any IP-related contract or indeed any form of commercial contract. And we've been able to tell ourselves that to do this exercise, there are three major steps which we may need to embark on: the IDA, the identification, the determination of the legal right, and the ascertainment of the ownership and validity of such rights. And we have also shared some questionnaires which we may rely on when we are conducting the exercise. And on that note, ladies and gentlemen, I dare say that I have come to the end of my presentation, and I do hope that we find it a bit useful. Thank you very much.
Thank you, Mr. Obafemi Agaba. We'll take questions and then comments later on, but I don't know whether, Simi, are you there? Simi?
Yes, I am. Good afternoon.
Simi's question time, so we'll yield the floor to you, then I'll come back towards the end. Thank you.
Thank you very much. Thank you very much, Mr. Agaba. Good afternoon to everyone, and thank you for joining today. Well, this section is a very interesting one, and I would say it's not just for anyone who is learning or planning to know about IP. It's also very, very important for practitioners, especially practitioners who do lots of commercial transactions. Thank you for breaking it down. I was writing all the way through and learning more. Thank you very much for today. Thank you. So we'll go straight to the question, and I think we'll start firstly with questions that relate to what we've done today. So the first question here is, what is the framework for valuation of IP rights?
Thank you very much. Am I taking the question straight away?
Yes, you are, sir.
All right. Thank you very much for that question. Now, the valuation of IP right is a whole subject on its own. And I dare say that the professionals which you need to conduct an effective IP valuation comprises not just lawyers, but also tax administrators. So it's a whole subject on its own, which is very important. And I think the three concepts which we need to bear in mind would be IP audit, IP valuation, IP due diligence. Now, it is when you do your IP audit, you can begin to look at the question of valuation. And I think that beyond whether there is a regime for that in Nigeria, is that commercial experience has made it become imperative for us to start looking at questions of IP valuation in Nigeria. A number of IP valuations that I've had cost to undertake for clients have necessarily involved us working with foreign partners, because of the very technical nature of it, going beyond just legal issues to financial and taxation related issues.
Thank you very much, sir. Thank you for answering the question. So the next question is goodwill an IP? And if so, what type of IP?
Okay, so goodwill, interesting. I like that question. So let me put it in a simple manner. I would say that goodwill, you can say that, yeah, it's a form of IP. It's a form of IP, right? And let me break it down. Let's go to trademark. A trademark, we all know what trademark is. But trademark is one of those IP rights you are encouraged to register. When you register your trademark, what it gives you is a right of exclusivity by virtue of Section 5(2) of the Trademarks Act. It says you have an exclusive right to exploit your trademark without the intervention of another party. And in fact, you can stop any other party from exploiting that trademark. So you have what is called a statutory right in that trademark. However, it is possible that your trademark is registered or it is not even registered. Where your trademark is not registered, it simply means that you do not have a statutory right in that trademark. And the implication of that is that you are unable to sue anybody that violates your trademark. You are unable to sue that person for infringement. So you can't go to court for the cause of action of trademark infringement. And the advantage of trademark infringement is that it puts you in a bit of an easier position as a plaintiff. In other words, the need to prove, confusion is limited. The law already assumes you have this right. You are not proving any much more than the presentation of your trademark certificate. Okay? Once you have that, and we can see a situation, especially a situation of what I call double identicality, an identical trademark being used in respect of identical product, you almost are likely to succeed in a trademark infringement. So it makes your case easier. But if that trademark that is being violated is not registered, you can't sue for trademark infringement. But the law allows you to sue in passing off. Now, for you to sue in passing off, one of the fundamental elements, the three fundamental elements of passing off is goodwill. And what is goodwill? And I think it's important to clarify it. Goodwill does not inhere in a trademark. It is not the trademark that is goodwill. And it's not the trademark itself that just gives you goodwill. Goodwill inheres in the business. Goodwill inheres in the business. And how does the business acquire goodwill? You acquire goodwill in the business by you trading in the particular goods or services. You have been trading in the particular goods or services using a particular trademark. So you are using that trademark in respect of the goods. You have used it to advertise the goods. You have used it to sell the goods. You have used it to export or import the goods. You have used it to carry out promotional activities, advertisements in respect of the goods in a manner that the public now know of your business. They now know of your business, and whenever they hear that trademark, all they can think about is your business. It means that your business has acquired reputation and goodwill by virtue of the use of that trademark. That goodwill is what the law concedes to you as a form of legal right. It's a common law right. The goodwill is a common law right, which the law concedes to you as a legal right with which to sustain a cause of action in passing off. So if we can say that, it therefore means that you can very well describe goodwill as a form of IP right, or more like a legal right to protect your IP right. I don't know if that makes sense.
Thank you very much, sir. Okay. Yes, thank you very much. So the next question is on this. This is a live case. A guy with an invention is introduced to two financiers and they agree to form a partnership to produce, market, and sell the invented products. Given this scenario, sir, who can it be said owns the invention? Note they are still at the agreement stage.
Could you take that again, please?
Okay. This is a live case. A guy with an invention is introduced to two financiers and they agree to form a partnership to produce, market, and sell the invented products. Given this scenario, who can it be said owns the invention? Note they are still at the agreement stage.
So the simple answer to that is that if there is a man who has invented something, a device or whatever he has invented, and he has obtained his relevant IP rights for that invention, he is the owner of the invention. Even if he is going into any contract with any third party for the exploitation of that invention or the commercialization of that invention, to the extent that they haven't done anything, he is still the owner, but his ownership right may then be compromised by whatever terms of contract they come into at the end of the day.
Thank you, sir. The next question says, can we really say all IP due diligence can exclusively be carried out by lawyers, or do you need other professionals to assist? An example readily comes to mind. How do lawyers audit or carry on due diligence on goodwill that a client's product or service had garnered over the years?
Okay, so like I said, to a large extent, due diligence is fact-based. So you are going on a fact-finding mission. And you know that as lawyers, we thrive on facts, okay? And we apply our law to facts, okay? So in a similar manner, in IP due diligence, what the lawyer is going to go and do is to seek facts. And it is the facts which you have that you will analyze in order to make your judgment. So even the goodwill which you're talking about, your questionnaire is going to ask a lot of questions. Is this trademark registered? The answer is yes. If the answer is yes, where is your trademark certificate? You look at the trademark certificate. Is it still valid and subsisting, or has it expired? Has there been a renewal? Those are the questions. If the trademark is not registered, the next question you want to ask yourself is that, have you been using the trademark? Yes. In respect of what product? This product. How long have you been using it? This is it. Where have you been selling it? Where have you been exporting it to? Have you conducted advertisement? What kind of advertisements have you done? Have you done promotional activities? What have you done? Have you won awards? All of these questions, the answers which you elicit from those questions will give you and will enable you to make an informed decision as to whether you can say to a large extent that that company may have acquired, that business may have acquired goodwill in respect of the goods and the trademark attached to it. So in summary, to a large extent, a lawyer can very well conduct IP due diligence. And if there are technical things he needs to clarify, I'm sure he can always clarify that. But IP due diligence is essentially the job of an IP lawyer who understands IP.
Thank you, sir. The next question is, thank you for the detailed presentation. How much is a fair charge to conduct IP due diligence for a client?
I think that's a difficult question to answer for so many reasons. One, a lawyer determining his fees might be a function of the amount of time, labor, and intellectual exertion is going to bring to bear on that activity. And secondly, may also be dictated by the reputation, the prowess of a lawyer to another lawyer. So I think it's a subjective, it's a question that would require a subjective answer.
Yeah, thank you, sir. So the next question here is, are trademarks territorial in nature?
Say that again, please.
Are trademarks territorial in nature?
Of course, trademarks are territorial in nature, which is why when you register your trademark in Nigeria, you have to register it in other places where you especially wish to exploit it. And you find that a lot of foreign companies and foreign products are also registering their products here in Nigeria because of the territorial nature.
Thank you, sir. The next question here is debt financing of IP. Thank you for your time today and efforts to simplify this topic. Please, can I get further explanation on the point debt financing of IP?
Okay, so the point we were trying to make there is that before now, when you go to the bank for facilities to get a loan, whatever type of loan, the only thing the banks used to think about would be real property as a form of securitization, as collateral. But we're beginning to see banks now getting interested in granting facilities on the basis of intellectual property as security for such facilities. So that's the point we're making, and that is also where IP audit becomes important, IP valuation becomes important. I know one of the banks that started about 10 years ago, they were very big on using IP as security for facilities. So that's what that's all about.
Thank you, sir. The next question here is on AI. Is an AI a legal person with the legal capacity to own intellectual property in Nigeria? If yes, where there is a breach by an AI, can you sue it under Nigerian law?
That's a very big question. That's a very big question. And to be candid with, I'm trying to remember a case where we did. So my view from the top of my head right now, and I think we've used it in a case before, is that a trademark, for instance, is meant to be owned by a person. And the definition of that in Nigerian law is that a person could be a natural person or an incorporated person. I'm not sure that as of today, that definition may capture AI. But I stand to be corrected and subject to further research on that. But to my mind, in the immediate, I'm not sure it may qualify based on the definition of a person. And I know that I think the Trademark Act sort of describes the ownership of a trademark right being inherent in a person.
Thank you, sir. The next question here would be, the lecture is rich, but it would be ideal if we taught the procedure in registration of IP and in particular trademarks. Thank you.
Okay, so the subject of my discourse this afternoon is more on intellectual property due diligence, which is a subject in commercial IP. The registration of trademark, which you referred to, is more a subject in IP prosecution. And I'm not sure that the training this year covers that as a major focal point. Even yesterday's presentation was not really on that. And I'm not sure tomorrow, I stand to be corrected, will cover that. So maybe it's something for the organizers to think about. Maybe next edition of this program can focus on registrability and registration of IP rights or trademarks in particular.
Thank you, sir. I think the topic tomorrow will cover this question.
Okay, great.
Thank you. The next question. Thank you for the insightful presentation. Can a domain name be an IP?
A domain name is a form of your IP. That's the reality today. And I always say to people, beyond the domain name being domain name, you'll find that most times your domain name is a product of your trademark. At the end of the day, you have the JEE.com. JEE is a trademark of Jackson AT and Edu, or you have GLIAS.com is your name. It has become your trademark, and your domain name would incorporate that. So to a large extent, it is safe to regard domain name as a form of IP right.
Thank you, sir. The next question here is, how does IP translate to a revenue stream for a company or an individual?
Okay, so very easily, Chimamanda Adichie, I'm sure, is a rich lady today. And I know that she's probably rich because she's written books where she has copyright in those books, and those books have been sold. There may have been adaptations of those books. I think one of our books has become a subject of movies. And the truth is, all the grant of those rights, the sale, the royalties proceeding from the sales of the book is money for her. Granting adaptation to make a movie out of our movies would have ended royalties. Again, the exploitation of that movie may also, depending on how a lawyer, drafts a contract, she would have made money from it. Again, when you have patents, you can give your patent to companies to manufacture it. For instance, a lot of money was made from COVID-19, while a lot of us suffered. There were lots of patents for those who came up with the vaccines and all of that. I'm sure they made billions in dollars from such patents. The man who does artistic work, sells his artistic work, collects money from it. The man who does music makes a whole lot of money from Apple, from other music sites. Once all of us are streaming and downloading, money goes to them. That is commercialization. That is them making money from their IP rights.
Thank you, sir. The next question here is, in what is your view? What type of IP category would information generated under AI and Web3 technology framework fall into?
Please say that again.
What type of IP category would information generated under AI and Web3 technology framework fall into?
And we're what?
Web3 technology. So I think it's still a technology that falls under artificial intelligence. Okay,
so I'm not too familiar with that technology, but the fact is that any work, once you download any work, anything that is in that written form will bring to mind literary work immediately, and literary work will qualify as copyright. That's breaking it down, okay? But if there are questions of inventions in the course of what the person who's asking the questions has asked, then you're thinking along the lines of patents for inventions. But if you are talking about something that has been printed out and contains some form of information in a permanent form, it might be a question of literary work that is protected under copyright.
Thank you very much, sir.
Okay.
Yes, I am back online. Thank you very much for answering the question. So I would try to go on with the next question. Where someone has registered a trademark or name and a more famous person later on attempts to register that same name, will the law protect the first person who registered, or is there a loophole that favors the more famous person?
Okay, so maybe let's turn that question upside down a bit. I'm suspecting that the more famous person, the questioner is talking about is more like whether another company or that trademark had been a subject of use by another company and has been made popular by another company or entity before this person that goes to register it. I think that might be my understanding of the question. And the reality is that if anybody has registered a trademark and a certificate has issued in favor of such a person, no doubt that person has the full protection of the law under Section 5 of the Trademarks Act. However, if there's someone else who has been exploiting this trademark and can show that he is indeed the true proprietor of the trademark, he is able to challenge the registration made by the other party under Section 35 thereabout of the Trademarks Act by bringing an application, filing originating motion for the expungement of that trademark, for the cancellation of that registration on various grounds, such as the fact that if that person is not the true proprietor, again, is also entitled to claim rights under Section 7, 9, 10, 11, 13 of the Trademarks Right, either by trying to go for concurrent use, honest concurrent use, prior use, and all of that. So it is possible for you, we need to remember the basic principle of Ogunleye and Oni in relation to land law, which says that even your certificate of occupancy is not a conclusive proof of ownership. So in the same way, and I've always said to people that your trademark right is just like your land law, your land right. But the same way, your trademark certificate may not be a conclusive proof and may be challenged successfully if the other party comes to court with the proper things.
Thank you very much, sir.
So the point there is, it's not about a famous person, but perhaps a mark that has been in active use before now.
Thank you, sir. The next question says, can two or more entities co-own a trademark or a class of trademark, whether name or device? If yes, what would be the likely long-term impact on either of the entities?
So two entities can co-own a trademark. That is very possible. That is very possible. And how they exploit that trademark to a large extent will be a function of their own agreement. Although I know that in some circumstances, especially in copyright, there are some regulation as to how you deal with rights that are jointly owned. But definitely you can co-own.
Thank you, sir. The next question will be, how effective would you say IP law has been in Nigeria, given the incessant breaches of copyrights?
So there would always be incessant breaches of any law, whether criminal law, regulatory issues, or indeed, civil arrangements. And I dare say that there has been, to a large extent, effective application of IP laws in Nigeria. However, much more is needed to be done. And we desperately need to pass a new Trademarks Act. I'm very happy we have the new Copyright Act. Can proudly say that I worked on that process at some point with the Copyright Commission. But the Trademark Act we've been trying to change for over 20 years. We need to change that to make the law more modern. I think that is important. I also think that we need some dedicated number of judges to do IP because it's a technical area of the law. And I think that the Federal High Court has become so inundated with almost general jurisdiction now that it's difficult for judges to keep up with specialist areas. I think that is an area where we need to work on. Another area we need to work on is on the enforcement by the police and other regulatory agencies to ensure that when judgments are given, the effects of those judgments are there too, and they are given effect to, are the things I would say. But I think we're making progress, that for sure.
Thank you very much, sir, for the answers. The next one is, can a person who is in process of registering a trademark and has obtained an acceptance letter from the registry maintain an action against someone who is exploiting the trademark?
Okay, so two views. Before now, the simple answer would have been that once you have your acknowledgement and acceptance, but you are yet to be issued a certificate, it would appear that that right of trademark registration is inchoate, has not fully crystallized in the absence of the trademark certificate. And to that extent, you are unable to sustain an action in trademark infringement. However, I think I may have come across one authority that says that, look, you have satisfied all you need to satisfy, and it is the government that is holding it. And so you, in effect, you have a trademark registration. And I've not had time to look at the Business Facilitation Act, because I think that one of the things it was meant to do, one of the things that is meant to do, and I think it has that provision now, that you will be deemed to have obtained registration once you have that acceptance. And to that extent, you might be able to sustain an action for infringement, at least relying on the business, is it BFA we call it now? Okay.
Thank you very much, sir. The next question says, on the issue of a domain name as an IP, web hosting companies allow registration on the same name with the difference of the .com, .co, .lo, etc., allowing Coca-Cola.com when there is a Coca-Cola.com. Oh, I'm sorry, this question is not complete, so we have to skip it.
No, we can answer. I think I have an idea of what the person is saying. And the simple answer,
okay,
the simple answer is that even where there are infractions in the registration of domain names, there is a dispute resolution mechanism to correct that, which you can apply to one of the agencies of WIPO to deal with that. And apart from that, you can also go to court. But they have this easy way you can easily resolve it. That we've handled for a number of clients.
thank you, sir. The next question is on practice. The question is, what are the steps a lawyer can take to venture into IP practice?
So one, I guess at this stage, continuous legal education, self-exertion, continuous legal education, and watching out for training. Being a member of APLAN might be very helpful. At APLAN, we do a lot of training sessions on intellectual property, and also having a mentor that is versed in that area of the law may also be helpful. I think that's what I would say. But very importantly, like I always tell young lawyers these days, personal exertion, you investing in yourself, buying books on IP, reading wide on IP, and taking WIPO courses will be very helpful. Taking WIPO courses would also be very helpful.
Thank you, sir, for the question. The next question says, what of international trademarks? Do I need to, or do businesses still need to register locally in different jurisdictions?
Yes, you need to have your registrations in different jurisdictions, whether by way of direct registrations or designations, depending on what we do. But the point is that you must have your your right established in that country in order to exploit it fully.
Thank you, sir. The next question is on AI again. Where an AI composes the music or creates an artwork, who is the owner of the IP in the music or artwork?
Okay, so I think that's an area that is emerging, and I don't want to be quick to give answers to here. It's something that I would rather want to look more into. There have been different views as to ownership of rights flowing from AI. Is it a question of the inputs by those who have put it together, or do you see the AI as a distinct individual in itself, capable of owning those rights? Issues to consider here.
Thank you, sir. And I think this will be the second to the last question. What are the types of transactions that require IP due diligence? I think this person was not, maybe the person did not join us early.
So we mentioned that in the course of the presentation, and we said it basically bifurcates into two. There are some contracts that are IP contracts in themselves: trademark licensing, trademark assignment, patent licensing. These are IP contracts. You need IP due diligence. And then there are some other broader general commercial contracts like mergers and acquisitions, joint venture, private equity related transactions. All of these always have IP content, and it might be important that in the course of conducting the general due diligence, you put considerations to IP contents of such due diligence as well.
Thank you very much, sir. Thank you for taking out the time today to respond to our questions and everyone's question on this group. Thank you very much. The last question is to Mr. Tobena. It says, good afternoon. You made reference to a YouTube channel yesterday, and I did not quite get the name of the channel. Please, I would like to know the YouTube channel. Thank you. Thank you very much, Mr. Agaba. Thank you, everyone.
Thank you.
See, I wasn't expecting to answer any questions today because it is clearly Mr. Agaba's day. But the YouTube channel is MBA HQ. I posted it on chat box earlier on. MBA HQ. Okay, now to the real business of the day. Mr. Obafemi Agaba, what a presentation. Thank you very much. I think we were up to capacity right through the session, the training session, and it means that people were truly, thoroughly engaged. I found the session very engaging and illuminating myself. There's a lot, I mean, I was wondering how easy or difficult it was going to be to speak about IP due diligence for the length of time you spoke on it, but it was quite a brilliant delivery and quite instructive and educative. And I think that the comments on the chat box bear this out. So thank you very much for your indulgence. And I on behalf of the president of the MBA and the Institute of Continuing Legal Education, we are very grateful. It is not easy to get someone of your caliber to be part of our sessions, and indeed to spend as much time as you spent with us today. But you have always obliged us. You've been a very important member of this faculty. So thank you, and truly God bless you for all that you do. We are grateful.
Thank you very much. It's been a pleasure, and we consider it a privilege. Thank you so much.
Thank you, sir. And dear delegates, thank you very much for tuning in today and for engaging with this process. Tomorrow we will have Chinasa Owana and Simi Oyelude taking us through. Thank you very much, and I hope you all join today. I ask you to encourage as many of your colleagues as possible to continue to be part of the work of the MBA ICLE. Let us promote learning and development, because we're all knowledge merchants, and the only thing we can do we trade with is knowledge, so we can push our profession from the notion of welfare to actually empowerment and capacity. Thank you very much, and God bless you all. See you tomorrow.
Thank you.